we'll be discussing on um, the justifying circumstances under Article 11. Okay, justifying circumstances. When you talk about justifying circumstances, what do you mean? If present, what is the consequence if there is a justifying circumstance in a particular case? If there's a justifying circumstance, then it is deemed as the act is in accordance with law. Uh, that is, it is legal. That the act performed is lawful. So therefore, in justifying, there is no civil liability, a criminal liability. There is no criminal liability because the act is deemed to be in accordance with the law. Okay? It is legal. And how do you compare this to Article 12? Article 12 speaks about exempting circumstances. Okay? What is the similarity and the differences between the two? Okay? The similarity is that both of them have no criminal liability. As we mentioned a while ago, in justifying, there is no criminal liability because the act is in accordance with law. No? So the act is lawful. In exempting, there is also no civil liability, no criminal liability. But the reason is different from that of the justifying. If in the justifying, the act is deemed to be lawful, in exempting, the act is what? Um, there is a crime, but there is no criminal liability. Merong krimen na nagawa, but there is no criminal liability. There is no criminal liability because of the absence of the elements of voluntariness. Pag sinabing ano bang voluntariness is tanggalin mo ang freedom, tanggalin mo ang intent and intelligence and intent. Like freedom. Freedom is negated by irresistible force. Irresistible force is what? Okay, it is an exempting circumstance. Okay, imbecility, if a crime is committed by imbecile person or by an insane person, or one which is committed by a minor who is less than 15 years of age, or above 15, below 18, acting without discernment, he lacks intelligence. Okay? Bawa, yung isang bata, no, a 10-year-old child who stabbed and killed his classmate, who is also a 10-year-old child. Okay, is there a crime committed? Yes. May namatay. A classmate died. Is there criminal liability? No, because because of the absence of intelligence. Sabi natin, kung ang edad ng bata is 10 years and below, there is no criminal liability. So, in justifying, no criminal liability. In exempting, no criminal liability. In justifying, because it is perfectly lawful or legal or in accordance with law. In exempting, no, there's a crime, but there is no criminal liability because of the absence of voluntariness. Okay, insofar as civil liability, this is where they differ. In justifying, there is also no civil liability. Talk about justifying, no criminal as well as no civil liability. Is, is this rule an absolute rule? No. There is an exception, which is paragraph. Okay. Paragraph 4 speaks about avoidance of greater evil. What about in exempting? In exempting, okay, opposite to that of justifying, there is civil liability. Usually when it's asked in the bar exam, you differentiate between the two. Differentiate justifying from that of exempting circumstances. So no criminal liability, in justifying, no civil liability as well. No criminal, no civil liability, except paragraph 4. In exempting, no criminal liability, however, it differs in justifying in that there is civil liability. Except paragraphs 4 and 7 of what? Article 12. Now, dito, paragraph 4 of Article 11 sa justifying. Sa exempting, there is civil liability except paragraph 4 and 7. 4 speaks about accident. And 7 speaks about prevented by some lawful or what we call as insuperable cause. In these instances, there are no civil liability. But the general rule is that there is civil liability. So this is how they differ, both of them. Okay? Next. Now let's go to the instances of justifying circumstances. The first instance refers to self-defense. The, the second instance under justifying is defense of a relative. The third is defense of a stranger. Okay. Number one, so far as self-defense is concerned, you have unlawful aggression, which is also the first element of defense of a relative and defense of a stranger. Pare-pareho sila. Pag walang unlawful aggression, there's no self-defense, defense of a relative as well as defense of a stranger. Second, there is a reasonable necessity of the means employed. Reasonable R&M, necessity of the means employed to prevent or repel the same. This is also the second element of defense of a relative and defense of a stranger. Third, this is how they differ. Insofar as self-defense is concerned, this is peculiar to it. There is lack of sufficient provocation on the part of the person defending himself. Lack of sufficient provocation on the part of the person defending himself. Okay? Defense of a relative. Defense of a relative. What is the third element? In case the provocation was given by the person attacked or the person being defended to, the person the, the person defending or the one claiming a defense of a relative have no part therein. Ibig sabihin, kahit na yung, di ba, sa defense of a relative, meron siyang taong dinidepensahan. Kahit na ang provocation comes from the person na who is being defended to by the accused, in case the provocation comes from him, for as long as the accused who defended him have no part therein, then he can claim defense of a relative. Third, defense of a stranger. Talk about defense of a stranger. The third element, they differ in the term in the third element. Okay, he should not be induced by revenge, resentment, or evil motive. Okay, I'm sure you memorized this already. Revenge, resentment, or evil motive. So on the third element, they differ. But on the first and the second, they are perfectly the same. But all you have to know is, so far as our defense of our relative is concerned, you should know who are the relatives. If it does not fall under this one, it probably will be a defense of stranger, provided that all of the elements are present, provided that he is not induced by revenge, resentment, or evil motive. He had other reasons why he seemingly defended the stranger, but because there is already an existing grudge between him and the victim, and he had evil motive or resentment, or it is an act of revenge, which is the primary consideration why he defended the stranger, then it is not applicable. He cannot raise the same. Let's go on one by one on what is lawful aggression. Just erase this one. Okay. You talk about unlawful aggression. What does it mean? Basic principles in unlawful aggression is that, number one, it should not be induced by revenge. It is cannot be based on suspicion and gut feel or mere conjectures. No? Hindi pa pwede yun. Hindi pwedeng gut feel mo lang, hindi pa pwedeng, ay baka ginawa niya yun or what. Hindi. It must be actual or imminent. It cannot be based on surmises, conjectures, or suspicion. It must be actual or imminent. When you talk about the word imminent, what does it mean? It means that it is at the point of happening. It is the point of happening. Okay, there is what? Peril. Peril to one's life, limb, or right. Pag property, coupled with also peril to one's life. When you talk about peril, ano ibig sabihin peril? There is a danger or threat. There's a danger or threat to one's life, limb, or right, which is actual or imminent. So, if you're going to apply this, self-defense, there is an actual threat to one's life, or limb, or his right. No? Kung walang peril, kung walang threat, which is actual or imminent, there can never be self-defense. One cannot raise the same. If there is particularly peril or threat to one's life, danger or threat. Same goes with the defense of a relative. There must be a threat and danger or peril to the life of the person you are defending. Kung dumating yung person who is allegedly defending a relative, pero yung relative naman, walang actual danger to or imminent to his life, limb, or right, then there is no defense of a relative. Why? Because there is no unlawful aggression. And so also goes with the defense of a stranger. Dapat yung taong dinidepensahan mo, merong threat or danger sa kanyang life, limb, or right. If there is none, then forget about defense. Defense of a relative, defense of a stranger, defense of oneself. Okay? When you talk about reasonable necessity of the means of employed to prevent or repel the same, what is the consideration? Consideration is that halimbawa, pag ikaw ba yung sinampal, pwede ka nang gumamit ng baril para pagbabaril yung isang tao na sumampal sa'yo. No? Kung yun lang naman ang ginawa ng tao and he desisted already from doing the same. Okay? So the reaction is disproportionate, right? Again, we will ask if there is threat to this thing, to life, limb, or right. Now, does it also mean that just because a person is being attacked with a knife, no, or with a balisong as a weapon, he can only defend himself by using the same thing, a knife or a balisong, where he has already a gun tucked in his waist to defend himself? No, diba? So, if there is the test of reasonableness, if the weapon is the only available means to defend oneself, by all means use it. So, kung meron kang baril dyan at nanganganib ang buhay mo, ay nahabol ka na ng saksak, hindi pa pwede tumakbo at paghahanap pa ng palaksak to defend yourself. If you have a gun, by all means, if this is only the available means to defend yourself at that particular time when there is peril to your life, then by all means use it. No? So that's the test of reasonableness. That's the first one. Second one is if the person has acted under the instinct of self-preservation. If he acted under the instinct of self-preservation at that moment, okay, to defend himself, like self-defense, no, by all means use it. By all means do so. Okay, you are not being prevented from doing so. When you talk about lack of sufficient provocation, the third element, lack of sufficient provocation. Let's talk about sufficient provocation. Sinabi ng batas, lack of, does it talk about provocation? Lack of provocation? No. It talks about lack of sufficient provocation. Magkasama yan, magkarugtong yan. If you answer it in the bar examination, and you also only indicated provocation, that is wrong. Because there could be provocation, the provocation is not sufficient. Okay? When you talk about sufficient, it is proportionate. Proportionate or adequate for one to steer its commission. Adequate to steer one to its commission. Okay? That's the meaning of lack of sufficient provocation. Sir, pwede bang magkaroon ng, a person can still raise self-defense even if there's provocation? Yes. Okay? So I will go to show you situations when one can raise still self-defense. Okay? Pwede, you can still raise self-defense under the following condition, even if there is provocation. Number one, okay? if there is provocation, but it is not sufficient. So person can still raise uh, self-defense even if there's provocation, for as long as it is not sufficient provocation contemplated under the revised penal code, or it is not adequate to steer one to its commission. So, still, the accused may raise the same. So, number two, even if there's sufficient provocation, but it is not, if it comes from a stranger, hindi nang galing sa person claiming uh, self-defense. And number three is, paano sir kung merong sufficient provocation coming from the accused? Even if there's sufficient provocation from the accused, for as long as it not immediately preceding the act. Okay? If it is not immediately preceding the act, he can claim still self-defense. So, ergo, okay, as I mentioned a while ago, person can still claim self-defense if when there is provocation on the following. Number one, uh, there is provocation but not sufficient. Secondly, there is a sufficient provocation but it comes from a third person. And number three, if there is sufficient provocation coming from the person defending, for as long as uh, the accused or the person claiming self-defense, for as long as it is not immediately preceding the act. Okay? Tandaan nyo to not immediately preceding the act. Sir, paano yung ano? So where can you not raise self-defense? So here, you cannot claim no claim of self-defense under this following condition. If there is sufficient provocation from the accused, which is immediately preceding the act. Immediately preceding the act. Tingnan nyo. Notice, almost the same sila, no? No? Ito, not immediately preceding the act. Even if there's sufficient provocation, not immediately preceding the act, acusado can still raise self-defense. However, no claim of self-defense if it is immediately preceding the act. Yun lang ang pagkakaiba nila. Pag ang sufficient provocation immediately preceding the act, no claim of self-defense. If the provocation is not immediately preceding the act, there can be self-defense. Example, halimbawa ay noong June 1, A slap B. With no apparent reason. No? They were invited guests in a particular birthday party for no reason at all. A slapped B. And B, of course, felt humiliated at that point in time. But he did not want to make a revenge at that time because there's so many people around. And he respect the one who celebrated the birthday. So he planned on taking a revenge. So on July 1, a month after, A, no, B made a plan to make a revenge. On July 1, 1 month after the incident, A intended to stab A. Now, fortunately for A was able to parry the assault of B and to defend himself, stab and kill B. Tandaan nyo, two incidents that happened June 1 and July 1. June 1, si A may kasalanan, A slapped B. But on July 1, 1 month after, it was B who took a revenge and tried to stab A. Fortunately for A was able to parry the blow and instead stab and kill B as an act of self-defense on his part. Now he was prosecuted for the death of B. A claimed self-defense on his part. Is the argument raised by A proper or not? Okay, assuming the two elements are present, of course, there's a lawful aggression under July 1 and reasonable necessity because he acted under instinct of self-preservation. Now, the only thing to determine is the third element. There is sufficient provocation on the part of A? Yes, because of what happened on June 1. Is it not immediately preceding the act or immediately preceding the act? It is not immediately preceding the act. So therefore, ergo, he can claim still self-defense. Why? It happened on June 1. And there are two incidents, June 1 and July 1. So the sufficient provocation is not immediately preceding the act because the sufficient provocation happened a month ago. Now, if it all happened on June 1, A slapped B. So as an act of revenge, B pulled a knife and about to stab A. Fortunately for A was able to parry it and instead stab and kill B. It all happened on June 1. Can A claim self-defense? No, because there is sufficient provocation on June 1. A all of a sudden slapped B. And the act of defending himself happened only just few minutes ago. Were it not for the slap of that he made against B, B would not have pulled up his knife. Immediately pulled his knife. So here, one cannot claim self-defense. Kasi bakit ito? Kasi may time for B to regain his composure. No? He can have the time to reflect and meditate in June and between June and July. Ito B talaga napahiya siya meron siyang palaksa. So to defend himself, no, felt humiliated that he intended to stab A, but A successfully fired and instead killed B. He cannot claim self-defense. Okay, so let's go to defense of a relative. Defense of a relative. Who are the relatives being referred to here? Una is at yung spouse, ascendants, descendants. So in direct line, no? Pataas at pababa. Spouse, ascendants, and descendants. Next, you have also the legitimate, natural, or adopted brothers, sisters. Okay, mga siblings at kapatid mo. Third is relatives by affinity. You talk about relatives by affinity, they are relatives because of the law. So when you marry, immediately you will have relatives by law. You will have your parents-in-law, brothers-in-law, okay? And these are relatives by affinity within the same degree. Hindi mag-apply yung relatives by cousin-in-law. Walang ganun. No? Pag sinabing relatives by affinity within the same degree, it refers to here, your ascendants, descendants, and it refers also to brothers and sisters. Of course, that includes your spouse. Relatives by consanguinity. These are relatives by blood. No? Dugo. Kadugo mo siya, and it will extend up to the fourth civil degree. Hanggang first cousin mo lang. Hindi pwede anak ng cousin mo, hindi pwede second cousin mo. So, we're relatives by consanguinity within the fourth civil degree. And how do you determine yung, yung line of degree? You go back to your common ancestor. So, halimbawa si X sa kanyang father, then yung kanyang grandfather, then yung kanyang aunties and uncles, okay? And next would be your first cousin. Okay. Between the father, you have the first, then yung relatives niya of the second degree is yun, umakyat siya sa common ancestor, who is the grandparent. Then yung auntie niya or aunts or uncles would be the third civil degree. And then the fourth civil degree is your first cousin. So up to that extent only. So ang tanong ngayon is, paano yung child ng first cousin? Ang child ng first cousin, we will consider is this as a relative within the fifth civil degree, right? So it's not the child of your first cousin is not included among the enumerations anymore, right? So if you defended the child of your first cousin, it's not a defense of a relative, but it could be a defense of a stranger provided that he is not induced by revenge, by resentment, or evil doing. Okay? An example, let's just give an example of this. Bawa, defense of a relative. Si A, si B1 at B2, magkapatid. So, B2 went to the CR. Pwede na natin i-call. B2 waited for B1, who went to the man's bathroom or comfort room. So he met X, and they had an altercation, X and B1. So they have an altercation, and then it became a heated argument that, B1, no, kasi si B1 is a black belter. He actually molded X. So what happened is that so B1 was on top of X. X was lying helpless. So helpless na siya. And B1 continued to strike and still box X. Now, B2 waited for so long. So nainip siya. He went inside. And he saw all the situation in this. Ito nakita niya. When he entered that he saw that B1, his brother, was the one boxing X, was already defenseless at the time. So B2, because B1 was his brother, went and stabbed X, which caused a mortal wound on the part of X, and he died. Prosecuted for the death of X, ang sabi ni B2, it was a defense of a relative because I saw B1, my brother, fighting with X. Question, can he claim a defense of a relative? No, he cannot. Why? Because at the moment when he entered the premises and he saw B1, ang tanong doon, is there a threat, a danger on the life of B1 at the time that he entered the scene? Is there peril to his life, limb, or right? There's none, right? In fact, B1 should have stopped because X was already defenseless at that time. No, and um, by doing so, then he will become B2 would be a principal also for mauling or injuring X. Because B1 could only perform an adequate force to defend himself. But since X was already defenseless at that time, he should have stopped. So when B2 entered, he became also a principal. It would have been different if it was X who was on top boxing his brother B1. And B1 was helpless at the time that B2 entered the picture. And B2 stabbed and killed X. Then that will be a proper defense of a relative. Why? Kasi nung dumating siya, there is peril to one's life or limb of B1. Huh? Now, even if it was B1, no, halimbawa, they had an altercation with X. Si B1 ang that provoked X. No, itinulak niya si X, minura niya si X, karatista pala si X. No? So, they had a fist fight. So, uh, X prevailed over B1. But when B2 entered the picture, for as long as he saw that his brother was in danger, then he can perfectly defend his brother, although for as long as B2 had no part therein. And the same also goes with a stranger. The same also goes with a stranger. Natandaan niyo sa stranger, not induced by revenge, resentment, or evil will. If you had other reasons to defend the stranger, like he would want to take a revenge on the person that seemingly attacked the stranger, then he cannot and will not be able to raise the defense of stranger because he is induced by such revenge. Next. Let's go to defense. So let's. Okay. So let's go to the accident. What is an accident? Accident is when avoidance of greater evil. Avoidance of greater evil. When the evil sought to be avoided actually exists. And still looking. Paragraph 4 speaks about avoidance of greater evil. Avoidance of greater evil. Uh, the evil sought to be avoided actually exists. The evil must actually exist. If the evil sought to be avoided is merely expected or anticipated or may happen in the future now, then it's not applicable. And the greater evil should not be brought about by the negligence or imprudence of the actor. When the accused was not avoiding any evil, he cannot invoke the justifying circumstance of avoidance of a greater evil or injury. The evil which brought about the greater injury must not be a result also from a violation of law by the actor. So halimbawa, si A was at the point of ano, si G at saka si Boy, si girl at si Boy. G is engaged to be married kay Boy, no? But on the night of their wedding, um, G had a soul searching. And the soul searching is that ang tanong niya is whether he actually truly loved this guy. No, mayaman naman si Boy. He spent for all the expenses of their marriage. No? Sa church, sa food, sa catering, and then sa clothes, everything. No? But on the night of the wedding, si G realized that he doesn't love this guy. So comes the wedding day, the following day, G did not appear. So B was really fuming mad, and he felt humiliated and embarrassed before the presence of their guests and sponsors. So sabi niya, sadya ito. Nag-file siya ng demanda, which is slander by deed. No? Ang tanong, will it prosper? Ang defensa naman ni G, avoidance of greater evil. So, anong greater evil? Yung mukha ni B? Hindi. Kasi mayaman si B, di ba? Mayaman siya eh. So, what is the evil sought to be avoided in this case? The evil sought to be avoided in this case is going into a love. How do you characterize that marriage? Pumasok ka sa sa marriage na hindi mo mahal ang spouse. Going into a loveless marriage. So that is the evil sought to be avoided. Okay? And it is perfectly a proper defense. But will she incur criminal liability? Yes, because under uh, Article 11, okay, Paragraph 4, avoidance of greater evil, this is the only instance where there is actually a civil liability. Number 5 is fulfillment of duty or lawful exercise of one's right. Looking for the caudal provision. Wala. Okay. A person who acts in the fulfillment of a duty or in the lawful exercise of a right or office. That's number 5. Number 6 is any person who acts in obedience to an order issued by a superior. There is a, sabi niyo, lawful exercise of right or office. So, what is this doctrine of self-help? Huh? The doctrine of self-help under Article 429 of the Civil Code. The owner or lawful possessor of a thing has the right to exclude any person from the enjoyment and disposal thereof. So, meaning to say he can use force as may be reasonably necessary to repel or prevent an actual or threatened unlawful physical invasion. So, halimbawa, yung property mo, somebody invaded that, no? Pumasok sa real property mo, you can defend. You can use a reasonable force to defend your property. That's the doctrine of self-help. No? What about lawful exercise of right? It is not necessary that there be unlawful aggression against the person charged with the protection of the property. No? If there is unlawful aggression against the person, no, charged with the property, protection ng property, then ang mag-apply yung paragraph 1 of Article 11. Maging, no? It being a defense here because it being a defense of property. When you talk about number 6, obedience to an order issued for some lawful purpose. What are the requisites? Dapat yan lawful order, lawful means. No? So number 1, of course, there, pag sabing obedience to an order issued for some lawful purpose. So therefore, there should be an order. An order issued by a superior. That's number 1. Number 2 is that the order must be for some lawful purpose. Number 3 is that the means used by the subordinate to carry out said order is lawful. So lawful purpose, lawful means. No? Both the person who gives the order and the person who executed it must be acting within the limits of the law. Dapat yun, parehong uh, perfectly lawful or perfectly legal. Halimbawa, merong gera sa Mindanao, halimbawa sa Marawi. And the soldiers were ordered to secure building 1 and building 2. Now, they were able to secure building 1. And they had some prisoners of war who surrendered to them, surrendered the weapons, no? But their assignment is also to go to building 2 to secure the same. So what must they do? Sabi niya, what must we do to these prisoners of war? Kasi we have to secure building 2. So the lieutenant order his sergeant to kill all the prisoners of war because there will be a burden to secure building 2. Now, prosecuted for the death of their prisoners, no, si sergeant claimed uh, uh, obedience to a lawful order. Question, okay, is that proper or not? Depende ba yun? The answer is no. Why? Because the order is unlawful. Why do you say it's unlawful? Because every soldier, no, they know that killing their prison is not justifiable under any circumstance. No, walang justified na parang patayin yung kanyang yung preso na surrender na at wala ng mga weapons that does not pose any threat anymore to you. And this is guaranteed under the Geneva Convention, where the Philippines, of course, recognized and is the same and is even a signatory to it. So alam yan ng bawat military. Now, ergo, so therefore, and in this case kasi, it is patently unlawful. So if it is patently unlawful and the subordinates still follow the order, then you cannot claim this last paragraph as a defense, as a justifying circumstance. So also, ergo, if the order is unlawful, but it is not patently unlawful, then still the person can claim this justifying circumstance of lawful order. Kung medyo nagtetread siya ng boundary, kasi halimbawa, under sa military operation, of course, your duty is to obey. You don't have to think lawful every time, lawful ba to or not? Nag-iisip ka pa, no? If it is not patently unlawful, still can claim this one, no? Obedience to a lawful order. Now, if it is patent, no, very glaring na unlawful yan, sabit ka. Okay? Okay, let's go to exempting circumstances. As I mentioned, in exempting circumstances, there is a crime, but there is no criminal liability. Okay, let me check if I have the code provision here. Okay. Circumstances which exempt from criminal liability, the following are exempt from criminal liability: an imbecile or insane person. An imbecile or insane person, if in insanity, unless the latter had acted during a lucid interval. First question, how do you distinguish imbecility from insanity? Okay? Kasi di-distinguish ng batas yan eh. Imbecile or insane unless the latter had acted during lucid interval. So imbecility is always exempting. Okay? An imbecile person is exempt in all cases from criminal liability. An imbecile is one who, while in advance in age, has a mental development comparable to that of children between how many years? 2 years old to 7 years of age. So ang kanyang mental development comparable sa 2 to 7 years of age. What about insanity? Is insanity always exempting? No. No? Because the insane person is not so exempt if it can be shown that he acted during a lucid interval. When you talk about lucid interval, nag-apply lang yan sa insane person. Sa imbecility, hindi siya pwedeng maging gano'n. So during lucid interval, the insane person acts with intelligence. And when you say acts with intelligence, so sane siya at that moment. No? What is the presumption? Presumption of insanity or presumption of sanity? All persons are presumed as what? Sane or insane? Katulad ngayon. Okay, the presumption is of sanity. The presumption is that all persons are sane. Of course, the presumption remains a presumption which can be rebutted, no? So, when a person was insane at the time of the commission of the felony, he is exempt from criminal liability. When he was sane at the time of the commission of the crime, no, but he became insane at the time of trial, what is the consequence? He is criminally liable. But, no, naging insane siya during the trial lang, then the trial will be suspended for the moment until he regains his sanity. So, evidence of insanity, the evidence of sanity must refer to the time preceding the act under prosecution or to the very moment of the execution of the crime. So, ang material yan, yung execution of the crime. If he is insane at that time, then he's exempted. If he was acting during lucid interval at the time that he executed or committed the crime, then he is liable. If he became only insane at the time of trial, then the trial will be suspended. Let's go to a person and under 9 years of age. This is, of course, you know this already, that because this was already amended by Juvenile Justice and Welfare Act. If the age of the child, uh, what is minority an exempting circumstance? It depends. If the age of the child is if the child age of the child is 15 or below, no? So this is total or absolute irresponsibility. Meaning to say, there is no criminal liability if the age is 15 or below. Eksaktong birthday niya o pababa, you don't even have to distinguish whether he acted with or without discernment. For as long as you can show the child's birth certificate and you can prove that he is 15 or below, then total exemption. Second, if the age of the child is above 15, when you talk about above 15, that's 15 years old or below. Above 15 and below 18, okay, you will have to distinguish whether he acted without discernment or with discernment. If he acted without discernment, then it's also exempting. But if he acted with this discernment, it's no longer exempting. And later you will know when we're discussing mitigating circumstance that it is a privilege mitigating circumstance. So tandaan niyo ito, 15 or below total exemption, above 15, below 18, for as long as you can show that the accused is acted without discernment, then he is not criminally liable. But he acted with discernment, it's not an exempting circumstance. This becomes what? A privilege mitigating circumstance. Now, yeah, I hope everything you got it right. Okay, number 4, any person who acted, who while performing a lawful act with due care causes injury by mere accident without fault or uh, intention of causing it. This is again a circumstance together with paragraph 7 when there is no civil liability. So elements, andyan na lahat ng elements. A person is performing a lawful act. Secondly, that he acted with due care. Thirdly, he causes an injury to another by mere accident. Fourthly, it is without fault or intention. of causing it. So what is an accident? An accident is something that happens outside the sway of our will. And although it comes about through some act of our will, it lies beyond the bounds of humanly foreseeable consequences. So if the consequences are plainly foreseeable, it will be negligence, a case of negligence. But if it lies beyond the bounds of humanly foreseeable things, no consequences, then it is an accident. Number 5, any person who acts under the compulsion of an irresistible force. Elements. Okay? When you talk about irresistible force, that force is what? There is a physical force. Number one, elements, number one, the compulsion is by means of a physical force. Second, and that physical force must be irresistible. Third, and that physical force must come from a third person. Like yung headbutt, hini-headbutt siya with a firearm, no? Sa ulo. Sabi niya, gawin mo to. You bury this guy. Otherwise, this physical force na being exerted in your head, no, will continue and you will die. Now, binary niya naman yung tao. Chinarge siya ng as an accessory for concealing the body of the crime. So, will they be criminally liable? No, because now there is an irresistible force. No, the butt of the gun, no, being used to hit his head unless he uh, with an order to order that the body of a particular person. So there is a physical force being exerted. Usually, when this is asked, you compare paragraphs 5 to 6. Paragraphs 5, again, it speaks about irresistible force, a physical force. But paragraph 6 speaks about when a person who acts under the impulse of an uncontrollable fear, of an equal or greater injury. So what are the elements of number 6? Number 1, the threat which causes the fear is of a greater than. Yung threat na yun, which causes the fear, is of an evil greater than, or at least equal to, that which is required to commit. That in which he is required to commit. Second, that it promised an evil of such gravity and imminence that the ordinary man would have succumbed to it. The basis of duress as a valid defense should be based on real, imminent, or reasonable fear for one's life or limb. It should not be, again, based on remote fear or speculative fear or fanciful fear. So, in irresistible force, the offender uses violence or physical force. But here, in a controllable fear, the offender employs intimidation or threat in compelling another to a crime. Again, itong number 6, meron siyang intimidation or threat. Sa number 5, meron ng di lang meron ng violence may physical force na which is irresistible. Irresistible. What else? Bawa a threat to kill a person. If you will not kill X, I will kill your daughter. Kinidnap niya na yung daughter niya. So that's the threat of being of equal. It's the life of this person where he is commanded to commit that crime, to kill that person, and also the life of his daughter. Kung di equal or greater injury, then this is not apply, will not apply. Halimbawa, patayin mo si X, ako nag-order, patayin mo si X, otherwise, I will fail you in your criminal law review class. No? So, equal ba yun? Diba? It's between the life. Meron bang tataas pa sa life ng isang tao? And compared with that of just a person who's just about to fail his criminal law review class. So it's not applicable. The seven is when prevented by some lawful or insuperable cause. Uh, so give me the requisites. What are the requisites of lawful or insuperable cause? Number one, that the act is required by law to be done. That there is a law that requires the performance of a particular act. Second is that a person fails to perform such act. And third, that his failure to perform such act was done due to some lawful or insuperable cause. Tandaan niyo yun. Halimbawa, a person is, there is a crime committed in the presence of a police officer. Um, and this happened in a remote area sa mountain siguro. Ito, nasa mountain. Okay? This is the nearest police station. This is the office of the city prosecutor. Office of the prosecutor. So nga, wala pang ganyan yan kasi provincial. Okay. Si A committed a crime in the presence of B, police officer. So what is the obligation of the police officer? To bring him down, magkaroon ng investigation sa opisina niya and then to file a case against A. So this is a warrantless arrest. And under the law, he has the duty to file a case, to deliver the case to the proper judicial authority, yung sinasabi ng batas, between 12, 18, and 36. 12 for light felonies, 18 for correctional, and 36 for grave or afflictive penalties. Now, assuming na ang the crime was committed is only a light felony, say, you only have he only has 12 hours to file a case against this A. And there's no means of transportation to go down. Nasira yung sasakyan ng police officer. So they have to go down. And just sa police station, umabot na siya ng 14 hours. And then another 1 hour. So 15 hours. Exceeded na siya sa 12. So ordinarily, he's liable for arbitrary detention. But because he is prevented by some lawful or insuperable cause as this one, so there is no means of transportation and going down and it's beyond his control, there's no negligence and even fault on his part, then this is deemed as a justifying circumstance. Okay? Okay, let's go to mitigating circumstances. Yeah. Mitigating. And let's compare this with aggravated circumstances. Mitigating circumstances, if present, would lessen the penalty without any aggravating present circumstances present. In aggravating, if present without any mitigating, then the penalty will be increased to its maximum. Okay. There are two kinds of mitigating circumstances, which are number one, ordinary, and secondly, it's a privilege. In aggravating, there is generic aggravating. Second, we have specific. We have number three, qualifying. Four, we have inherent. Number five, we have special complex threat. It cannot be offset by any mitigating. Please mute your mic, please. Pag special, katulad ng complex crime, sabi, the penalty in complex crime is the same for the most serious crime, the same to be imposed in its maximum period. So it cannot be offset. Okay, mitigating, ordinary and privilege. Ordinary, if present without any aggravating, then the penalty will be reduced to its minimum period. As a general rule lang ito. Minimum period. Privilege, if present, will be a reduction of by 1 or 2 degrees lower. So a privilege, meaning to say, when you talk about privilege mitigating, you talk about lowering it by a degree. Ang ordinary, if present, you reduce it to a period. Period. So nag-apply ito sa penalties without which periods. This is not applicable to penalties which do not have a period. Like what? Death or reclusion perpetua. Death and reclusion perpetua, no, they do not have a period. Why? Because they are deemed to be indivisible penalties. You talk about indivisible penalties, wala siyang minimum, medium, and maximum period. So when you talk about periods, reduction into its minimum period, you talk about a case where it is applicable to divisible, like reclusion temporal, 12 years, 1 day to 20 years. Okay? You divide it into 3. Equally, you have the medium, and you have at the left is the minimum, at the right you have the maximum. Period. So the horizontal pertains to period. So pag ordinary mitigating, it applies to a divisible penalty. It's not applied where the penalty is death or reclusion perpetua. When it's a privilege mitigating, it applies to both divisible or indivisible penalties. So if the penalty is reclusion perpetua and a person is acting, a minor, 17 years of age, acting with discernment, then the penalty will be reduced by 1 degree. So from reclusion perpetua, you have reclusion temporal. Okay? So be able to identify what are the mitigating circumstances. Be able to identify what are the aggravating circumstances. So na-memorize mo lahat under Article 30. But you need to memorize also the elements. Baka pamaya, akala mo, voluntary surrender. Hindi naman pala siya voluntary surrender. Kasi sumurrender siya kay Rafi Tulfo. Ha? Intindihin niyo yun. Ha? May mga pagkakataon na gano'n. Bawa si because yung voluntary surrender should be on a, before a person in authority or an agent of a person in authority. So kung sa private person siya surrender, although he surrendered, it's not voluntary, it's not mitigating circumstance. Titingnan niyo gano'n. And once you identify the same as a mitigating, you will also have to look whether it's an ordinary or privilege mitigating. In the same manner that in Article 14, once you see an aggravating circumstance, you do not offset automatically, because the ones that we use for under the rule of offsetting, remember this, kung meron kayong dapat tandaan, lalo na sa Islaw, ang ino-offset nyo lang is an ordinary mitigating as against a generic aggravating. So nakita mo siya, oy, aggravating, in-offset mo na agad. No. Make sure that it's a generic aggravating. What if it is an inherent one? No? What if it is an element of the crime? What if it's a qualifying aggravating? So, halimbawa sa chinarge mo isang tao, homicide, with a generic aggravating circumstance of murder, that's wrong. Because the crime is now murder. It becomes what? Treachery becomes a qualifying circumstance in the crime of murder. So, hindi lang basta-basta, oy, nakita mo, ito na yung, o halimbawa, nakita mo yung isang circumstance. There's an abuse of a public authority. Generic aggravating yan. No? In the crime of malversation, it's not a generic aggravating. It's inherent. You cannot, a public position is inherent in the crime of malversation. Why? Because the person who committed it is an accountable public officer. So, kailangan pagtingin mo, ay, generic yan. Pag hindi generic, wag mo i-offset. Pag nakita mo ng ordinary mitigating, offset mo yan. Pag privilege, baba mo kaagad yan ng degree. Regardless of the number of the mitigating or ordinary mitigating. So as early as now, I am already reminding you this kasi para ibuhos nyo yung aral nyo sa mitigating and aggravating circumstances. You will not be able to answer a question on indeterminate sentence law questions if you're not familiar or if you have not memorized what are the mitigating and aggravating. Tinrick kayo, nakalagay doon, a person has acted under irresistible force. Ginawa niyo siyang mitigating, binabaan mo. Proper or not? Mali. Kasi ang irresistible force is what kind of circumstance? It is an exempting circumstance. So, dapat alam mo, justifying, exempting, mitigating, and aggravating. Kung nakita mo, surrender siya sa voluntary, admission of guilt. Inadmit niya before the office of the city prosecutor. So, pinapunta sila sa submit ka ng counter affidavit. Hindi na po ako magsasubmit. Ako po'y umaamin sa krimen ko. So, yun. So, hoping that akala niya at the earliest time na mag-admit siya ng guilt ay this will constitute as a mitigating. Is a admission of guilt before the prosecutor, no, in the conduct of preliminary investigation, or mitigating circumstance? No, because it must be done where? In open court, no, before prior to the presentation of the prosecution's evidence. But it should be done in an open court and not before an admin body. So what does it tell you? It only goes to show that not only that you should be able to memorize, but you should be able to know the elements as well. And after knowing that, identifying that it's a mitigating circumstance, then you have to classify it, whether it's an ordinary or a privilege mitigating. Baka pa niya i-request kayo na mag-offset na marami na siyang aggravating na nilagay sa facts of the case, and you're unable to simply identify what are those ordinary mitigating circumstances. Let's go to mitigating. Yeah. The following are mitigating circumstances. Okay, when all the elements necessary to justify the act or to exempt from criminal liability are not attended. No? Let's go, for example, on this one. All the elements necessary are not exempt. What is the rule? Okay, so Halimbawa, self-defense. You have URL, lawful aggression, reasonable necessity of the means to prevent or repel the same. Third is lack of sufficient provocation. Okay? Assuming. Assuming that the ones who are present is unlawful aggression, present, walang reasonable necessity, walang sufficient provocation. Then what is the consequence? It is an ordinary mitigating. No? If unlawful aggression is present, the second and the third are not present, then ordinary mitigating. If unlawful aggression is present, reasonable necessity is present, the third one is not present, then it's a privilege mitigating. It's not simply a mitigating, but it's a privilege. If unlawful aggression is present, second is not present, lack of sufficient provocation is present. In other words, the first and the third elements are present, it's a privilege mitigating circumstance. Okay? If no unlawful aggression is present, but 2 and 3 are present, then it has no bearing. Because why? Because unlawful aggression is an indispensable requisite. So pag wala nito, kahit meron 2 and 3, then it will not be considered. Okay? Now, if these 3 are present, then it's no longer a mitigating circumstance. It's actually a justifying circumstance of self-defense if all the elements are present. So, alamin nyo lang, dapat, if the majority are present, then it's uh, it's a privilege mitigating. Okay? Okay. Um, let's go to kanina, age of a child, which is above 15, below 18, acting with discernment. Yung sinasabi ko sa inyo kanina sa exempting, when we were in exempting, if the age of the child is above 15 and below 18, then you will have to distinguish whether he acted with or without discernment. If he acted without discernment, then it's an exempting circumstance. If I acted with discernment, then it is not an exempting, but it is a privilege mitigating uh, circumstance. So when you talk about the concept of acting with discernment, what does it mean? Acting with discernment simply means that whether the person uh, know the consequences of his not, he knows what is right and what is wrong. No? Kung alam niya yon, then he acted with discernment. In one case, ang sabi ng Supreme Court is when the accused waited for the parents of the victim to come out of their house, and then when they left the house, then that's the time that they committed the crime. Then it only shows that the child had acted with discernment, and so therefore he is criminally liable, although it constitutes as a privilege mitigating circumstance. Okay. There's also incomplete justifying circumstance na naman ng performance of duty. Uh, uh, there are two requisites that must be present in order that circumstance under Article 11, number 5 may be taken as a justifying. Diba, sinabi natin kanina that he acted in the performance of a duty or in the lawful exercise of right or office, doctrine of self-help. And then, second is the injury, cause, or offense committed be the necessary consequence of the due performance of such duty or the lawful exercise of such right. No? Uh, Pagka incomplete yung mga yon, then it will be deemed already as a mitigating circumstance. Kung two as against one. Okay. Third is that sufficient ano yun, provocation or threat or that the offender, ayun pala, third paragraph, that the offender had no intention to commit so grave a wrong as that committed. So the circumstance can be taken into account only when the facts proven show that there is a notable and evident disproportion between the means employed to execute the criminal act and its consequences. Of course, when we talk about intention, uh, it is an internal state, yung intention. And it can be judged only by the manifestation of the external acts. So the intention as an internal act is judged not only by the proportion of the means employed by him to the evil produced by his act, but also by the fact that the blow was or was not aimed at a vital part of the body. Number three, number four, what is provocation? Kamali ako ng ano dito. That sufficient provocation or threat on the part of the offended party immediately preceding the act. So, what are the requisites? Ano ibig sabihin ng provocation? It is understood any unjust or improper conduct. Unjust or improper conduct or an act of the offended party capable of exciting, inciting, or irritating anyone. So, provocation. That the provocation must be sufficient, that it must originate from the offended party, and the third, that provocation must be immediate to the commission of the crime by the person who is provoked. Halimbawa, sa illustration kanina, sinampal ni A si B. Si B nag-pulled up the knife. At this time around, A was not able to defend himself. Kanina sa illustration ko, napatay niya pa si B. But what if A, with no apparent reason, slapped B and B pulled out a balisong and stabbed A? Okay? So, he is criminally liable. But he can claim sufficient provocation as a matter of privilege of mitigating circumstance. So there was a sufficient provocation, sinampal siya. Second, it originated from the offended party, si A. In that the provocation must be immediate. Yung ang pagsampal niya is immediate. Happened just before sinaksak niya or sinaksak niya si A after he was immediately slapped in his face. Number four, immediate vindication. Immediate vindication. Immediate vindication. There must, tingnan nyo dito, there must be an immediate vindication of a grave offense to the one committing the felony, a spouse, ascendants, descendants, legitimate, natural, or adopted brothers or sisters, or relatives by affinity within the same degrees. So how do you compare, usually, how do you compare 4 and 5? But let us give first the requisites of immediate vindication. Nakita niyo doon, may grave offense. So there must be a grave offense performed or done to the one, either to the one committing the felony or his relatives, who are his spouse, descendants, etc. Notice under this immediate vindication, it limits the relatives only by affinity within the same degree. So wala nang relatives by consanguinity within the fourth civil degree. Inalis na yun. So self-defense lang siya nag-apply. Okay, second requisite is that the felony is committed in vindication of such grave offense. So, a lapse of time is allowed between the vindication and the doing of the grave offense. So, between the grave offense and the immediate vindication, there could be a lapse of time. So, how do you compare immediate vindication from sufficient provocation? In the case of provocation, it is made directly only to the person committing the felony. Sa vindication, di ba, andyan very clear na yung grave offense may be committed against the offender's relatives, not only against himself, but also against his relatives. Yung enumeration of relatives are not included in sufficient provocation. Okay? And of course, there is, as I've mentioned, it must be a grave offense to the offender or to his relatives. Now, that grave offense, kailangan ba yan, should it be a felony? No, not necessarily. That the grave offense did not necessarily be a crime. So, ang pinaka-importanting distinction is that the sufficient provocation or threat immediately preceded the act. Meaning to say that there is no interval of time between the provocation and the commission of the crime. While in immediate vindication, there is proximate time or lapse of time or interval of time between dun sa grave offense at yung sa commission of the crime. So pag sinabing grave offense, ano ba to? It must be decided by the court lang, having in mind ano ba yung social standing ng person, yung place at time when the insult was made. Again, as I mentioned, it does not necessarily mean that the grave offense is a felony. Insult, that will be considered as a grave offense. In one case, nung araw, tinanan yung anak niya nasa baryo sila, tinanan yung anak niya, hindi nagpaalam sa tatay. Nag-elope. So, the father felt slighted. So, pinatay niya yung lalaking nagtanan sa kanyang anak. It was considered, in this case, as a grave offense, and so therefore, she can avail of immediate vindication as a mitigating circumstance. Number 6. Ito dapat number 6 and 5. Yung passion and obfuscation. Passion and obfuscation. That the person having acted upon an impulse so powerful as naturally to have produced passion and obfuscation. So this paragraph requires that number 1, the accused acted under an impulse. No? Number 2, the impulse must be so powerful as that it naturally produces passion or obfuscation. So, requisites, there must be an act both unlawful and sufficient to produce such a condition of mind. And that said act which produced the obfuscation was not far removed from the commission of the crime by a considerable length of time, during which the perpetrator might recover his normal equanimity. So meaning to say, no passion or obfuscation after 24 hours. No? The defense must prove that the act which produced passion or obfuscation took place at a time not far removed from the commission of the crime. And it must be the result of a sudden impulse of natural, uncontrollable fury. Nagselos ka. Nakita mo yung asawa mo, nakikipaghalikan sa driver niya. No? Hindi naman yung death under the exceptional circumstance. So, napatay mo yung driver mo. Nakita mo, naghahalikan sila. So, that's passion and obfuscation. Okay? So, Ang passion of frustration it must arise from a lawful sentiment. It must arise from a lawful sentiment or legitimate feeling. Katulad nung sinabi natin na yung nagselos yung asawa niya. Pero kung pinagselosan niya, yung kabit niya, eh married pa siya. So si H, married kay W. Meron siyang girlfriend. Yung girlfriend niya nangalawa. Nakapaghalakita niyang pagbalik niya sa condo na binigay niya sa kanyang paramour, no, nakikipaghalikan pala kay D, yung driver nila. So anong ginawa niya? Pinatay niya. At now he's raising that as passion of frustration. A question, can he raise that? No, he cannot because it must arise from a lawful sentiment or legitimate feeling. Meron bang illegitimate feeling? Meron pala. May illegitimate feeling. Hindi ka pwede magselos sa girlfriend mo kung ikaw ay married. So, ano ibig sabihin nun? Be faithful to your spouse. Diba? So, how do you distinguish passion of frustration from irresistible force? Passion of frustration, huwag niyong pagpapalitin. Hindi siya exempting, ha? Ang passion of frustration is a mitigating circumstance. Ang irresistible force, yan ang accepting. Yung passionate frustration cannot give rise to an irresistible force kasi irresistible force requires a physical force. And passion of frustration is in the offender himself. Yung irresistible force must come from a third person. Okay? And passion of frustration must arise from lawful sentiments, whereas irresistible force is unlawful. Okay. Number 6, offender had voluntarily surrendered to a person in authority or agents or confession of guilt before the court. Okay, let's go to voluntary surrender. Number 1, the offender had not been actually arrested. Pag arestado na siya, then this will not be appreciated. Secondly, he must surrender to a person in authority or to the latter's agent or to the agent of a person in authority. That the surrender must be voluntary. Alam naman natin, yung taong person in authority is one directly vested with jurisdiction. And agents of a person in authority are those charged with the maintenance of public order or protection and security of life and property. Pag sinabing voluntary surrender, dapat spontaneous yan. It shows the intent of the accused to submit himself unconditionally to the authorities. No? And the purpose is to, of course, to save the trouble and expenses necessarily included in his search and capture. So kung ang surrender niya, it will not actually save trouble and expense on the part of the government, then this will not be considered. Voluntary confession of guilt, spontaneous ang confession of guilt. Again, as I mentioned before, secondly, the confession of guilt was made in open court. That is before the competent court that is trying the case. And that the confession of guilt was made prior to the presentation of the evidence for the prosecution. Ergo, if the plea of guilt is made on appeal, then it is not mitigating. If the plea of guilt, as I mentioned earlier, at the preliminary investigation, is no plea of guilt at all. Okay? What about extrajudicial confession? The extrajudicial confession made by the accused is not voluntary confession as contemplated in the revised penal code, because that confession was made outside of the court. Again, as I mentioned, confession of guilt must be made in open court. Let's go to physical defect. Deaf, dumb, blind, some physical defect. Pagtanto rito, physical defect must restrict his means of action, defense, or communication. Physical defect referred to in this paragraph is such as being armless or crippled or which restricts his actions, defense, or communication, whereby his means to act, defend himself, or communicate with his fellow beings are limited. But this physical defect is not mitigating in the crime of rape, di ba? Or crimes against chastity, or in crimes against property. Illness. Such illness of the offender as would diminish the exercise of his willpower without, however, depriving him of his consciousness of his act. Okay? So the elements is that the illness of the offender must diminish. Naka-diminish naman yung exercise of his willpower, but it should not deprive the offender of the consciousness of his acts. Why? Because if he is deprived of the consciousness of his acts, then that is already an exempting circumstance. When the offender completely lost the exercise of his willpower, it is deemed as an exempting circumstance already. Okay? Then the last one, uh, analogous circumstances. Finally, any other circumstance of a similar nature and analogous to those above mentioned. So, over 60 years old, with failing sight, similar to over 70 years of age, mentioned in paragraph 2, article 13. Okay? The outrage feeling of a creditor, no, na kailangan gamitin yung bayad sa kanila para sa gamot, hindi siya nakababayad ng gamot at hindi siya nakabili ng gamot kasi hindi nagbabayad yung renter. No outrage feeling of creditor similar to passion and frustration. Also, a person who killed his debtor who tried to escape and refused to pay his debt is entitled to this mitigating circumstance, similar to that of passion and frustration. Or impulse of jealousy, of, of, of jealous feeling, similar to that of passion and frustration. Okay? Uh, Voluntary restitution of stolen property may be deemed similar to that or analogous to that of voluntary surrender mentioned in paragraph 7. Extreme poverty and necessity similar to incomplete justification based on state of necessity. Okay? The condition of running amok is not mitigating. Okay? So yun, we will have a break